I'm telling both parties, at the end of lunch today, when we reconvene after lunch, I will have those on my desk. Otherwise, you guys will be sanctioned. That's simple.
Your Honor, in regard to jury instruction, I guess was rescheduled. You got the plan meter at 10, but I was here and I guess,
I was here.
I was waiting for Kurt to, but we didn't get together, but at 10, so there was a little delay there.
So Judge, I provided a full list of everything that I stipulate to and everything that I object to. And I've actually provided a list to councils that I would even withdraw one in lieu of another one that's been proposed by them. I don't know where they're at, but I'm a little frustrated and I'm a little tired. And it's the same thing. And counsel's in there telling me I have to provide her a paper copy this morning. She got those jury instructions 2-3 weeks ago, and then she wants to know how they were served. They were served through e-service. I don't have that on me right now. I'm not going to produce it, but I'm frustrated because I'm just trying, but we're just not getting anywhere. And I thought I would get a list of what, at least what we could stipulate to, or what was unobjected to and what was objected to, so we could just talk about that.
Okay, counsel, where are we at on the ones that were provided by plaintiff, whether or not we have stipulation certain ones or not?
Well, I think all the general ones, there's not much disagreement, in regard to the general ones. We just got breach of contract and a few of the special ones. We've made some progress on those. We just got an email this morning. I just thought Chris just handed it to me for the first time. So there's, but we've also been proposed ones. I didn't repeat the general ones, so I think we're making progress.
Okay,
I just
guess what? That's what you guys are doing at lunchtime, because at the end of lunchtime, I will have before me a set of stipulated jury instructions and a set of proposed by each side that's not stipulated to. So that's your lunchtime.
My office manager informed me that I provided a paper copy to Ms. Anderson as well. That was
Counsel, it's not necessary, as long as it's been sent over. The question is what's provided to me. Okay, that's what, you guys can go back and forth and fight amongst yourselves all sense, but I want presented to me at the end of lunch today, a set of stipulated jury instructions and a set of proposed plaintiff jury instructions that were not stipulated to, and a set of defense proposed instructions that were not stipulated to. That's what's gonna happen, okay, understood?
Well, that's clear, proposed and, with the words on it, just as a number.
It's quite simple. I have a stack,
Yeah,
1 through
I
whatever it is.
understand.
These are agreed upon. Then I have plaintiff is proposing this jury instruction, this jury instruction, this jury instruction. It has citations. Those are being objected to. Defense has their proposed ones that are being objected to.
Yeah, I fully understand, Judge. It's just that, and this is not your concern, is that I just feel the plaintiff is just always trying to complain about something, doesn't cooperate on something, and complain about something. At least it could be done.
It's real simple. It's real simple. As the principal in this sandbox, I'm not gonna listen to it going back and forth.
I understand.
I'm telling both parties,
But at least
let me
you're-
finish, Counselor. I'm telling both parties, at the end of lunch today, when we reconvene after lunch, I will have those on my desk. Otherwise, you guys will be sanctioned. That's simple.
That's,
Marshall, let's get our jury in here.
All rise for the presence of the jury. All jurors are present.
Counsel, stipulate to the presence of the jury.
Yes, Your Honor.
Mr. Harris, please take a stand.
Thank you, Your Honor.
Please be seated. Mr. Harris, I'll remind you, you're still under oath. Counsel, for the plaintiff, continue your exam.
Thank you, Your Honor.
Good morning, Mr. Harris.
Good morning, Mr. Doyle.
Yesterday, in some of your testimony, you talked about changing the cost structure over there at Equal Rights. And you listed, some of the costs and things that have changed when it was connected with learning a law firm. Are there other reasons why the costs and expenses increased in the business?
Yeah, previously, when Ernest ran the business, the paralegals there, the associates, as they call them, the legal assistants, they had to pay for all the supplies there. And naturally, as a firm, we pay for the supplies. And just one thing that I don't really know all the exact details, But those individuals that testified make a great deal more money than what they used to make. Almost double. And they work hard. They deserve it.
Mr. Harris, yesterday you also testified about some of the posts that the defendants have been making online about yourself and the business. Were there other postings that caught your attention?
Yeah, I know in Cam's testimony, he talked about that Chris Aaron was kind of a focal point of Mr. Defendant Del Casal, that he used to malign him to some degree. And I did look up online and saw a post about Chris Aaron that had been made by Defendant Del Casal on his Facebook Defendant Court News.
You turn to proposed exhibit 61-012.
Mr. Doyle, I think I'm just gonna need my evidence binder.
Council approach?
Yes.
Council, we're looking at 61-002.
1-2, Your Honor.
1-2? Okay. And before we are looking at it, are we intending to admit this into evidence?
I was anticipating that, Your Honor.
Okay. Council, do we stipulate to it, or do we need to lay foundations, or do we have any objections?
I believe, Your Honor, this one was also unobjected to.
Council, are you on 61-012? It seems to be a posting with Mr. Del Casal in the middle of his posting.
I've got exhibit 61 here, it looks like it's 24 pages.
Yeah, we're dealing with page 012 or number 12 now.
I have no objection to page 12.
Okay, 61-012 is hereby admitted by stipulation. Go ahead, Council.
Mr. Harris, is this where is this post from?
This is a post from the family, actually it's from Defendant Del Casal's personal webpage. And it was just a post about, and it may have been on the Family Court News too, I don't know, but it was a post about, he'd been over at the courthouse and making his observations, his daily observations, whatever that was. And he just notes there in the first line that he saw Chris Aaron slithering and former Judge Luke looking like crap on the second floor. And that was common, I guess, to see those kinds of posts and those kinds of things. And so it wasn't just me that was kind of the focal point of some of this angst and statements. There were others, and there are others out there that are involved.
After he left the business and started his own business, and you started seeing these posts, did he ever make contact with you directly? Did he reach out to you?
No, there was never any direct contact. Nothing ever reached out, other than I did get a couple of emails, and one in particular was just kind of odd and a little off-putting or offsetting. I'm not really sure. I wasn't really sure how to take it. It was some email about that Mr. Saflita, who you saw testify on Monday afternoon, had created a problem that involved both of us, and that I was now on notice of that. And I just wasn't sure what that meant, or what I was supposed to do about it.
And that's, if you can turn to proposed exhibit 8.
8?
Correct.
That's it.
What was the date of that email?
I received that email on August 8th of 2016.
And this is a correct copy of it?
It certainly is.
You know, I'm not sure if this one was previously admitted, but if not, I'd like to admit.
Council, any objections to exhibit 8?
No.
Exhibit 8 is hereby admitted by stipulation.
Mr. Harris, this is the extent of the email communication?
Yeah, that's it. It just said that Saflita had created a problem that needed to be addressed, and that it could affect me. I guess it could affect you, I guess. It was just me, I guess. And I was on notice, but I didn't know what that meant or was. I didn't know. And I didn't know how to take it.
Did you ever clarify?
I didn't get a clarification. And this kind of came on the heels of the bar complaint. It was about a month later. So I was kind of done at that point. After I got the bar complaint, I pretty much shut down effort on
And that's exhibit 9, right? Or no, I'm sorry.
Yeah.
I don't seem to have that one. Included in mine.
Super nice.
Sorry, Ron, give me one. Okay, I see.
Exhibit 9, page 001002 seems to be the submission paper complaint to the bar.
Yes, thank you, Ron. And again, I don't know if this one is already been admitted, but.
Council Defense, any objection to exhibit 9, pages 001002?
There's no objection, but there needs to be clarification in your prior exhibit. The date needs to be, I think Kurt mentioned on the heels, but I think the date of the last exhibit would be helpful. Exhibit
So
eight.
he stated that he received it on August 8th, 2016. On the top of the exhibit 8, it says at 9:07 PM. It looks like it originated on July 11th, 2016 at 4:21 PM.
July 11th, right?
Okay, those are the dates of this. Go ahead. 9 is thereby stipulated in.
And Mr. Harris, if you can explain to the jury, I guess, what this is and how you receive it.
This is,
Try to zoom out a little bit. Go ahead.
anyone is permitted to submit a bar complaint online or contact the bar at any time at 382-2200 if that is something that you wish to lodge a complaint with. And so you can go online and you can make out a complaint against any attorney. They do ask you some perfunctory type of questions to make sure that you are a client, or at least you have a basis to make a claim or a complaint against an individual. And then they ask you for your personal information. One of the things I really noted on here was that he used this James Dean or JD Dean or something email. That was not the email that he had ever used with me. And I just thought that was odd, that JD1494 Gmail, that was the email that the bar was indicated to communicate with regarding his complaint, which goes along with the line of, he had a lot of different names and a lot of different emails, to my knowledge.
And then one of the phone numbers you used there, is that consistent with the businesses that he had started around that time?
No, I don't think so, and I don't know if that's a personal number or not. I never called it.
And then in the body of the email, does it contain any information about what's actually being complained about?
Yeah, on page 2, it has the full complaint that came in, and I was able to read that and review that, and I did share that with the people there at the office. Although they are strictly confidential, strictly personal, and are not disclosed by the bar to anyone other than the recipient of the complaint or the person that made the complaint. I did let them know that the complaint had been made, and that I had responded to it, or was going to respond to it. I'm gonna let them know.
And it complained about specific people?
Yes, it did. It really kind of gives an outline here. It does complain about Scott Cater and George Boyer and Cam Harris, who you've heard testify there at the top. And I thought it was odd that Arturo Sorosa was not mentioned in the bar complaint, because he was certainly there. But there was no mention of him there, and I just thought that was strange. But I knew that he and Ernest were friends, and it made sense that he didn't bring him into the complaint. But he did go after the rest of the individuals there, and name them as concerned parties, or whatever their preface there is.
And Arturo was still at the office at this point in time?
Yeah, he certainly was. He was there.
Was there anything else in the actual, body of the complaint that stood out to you?
Yeah, there's several things there. It just kind of gives us the preface for the future publication that he made against me. And he does, again, go back to those language, calling himself the director, and then he retired. Despite the fact that he was working, I'm not sure exactly what the context of retirement meant exactly. But it just talks more about what you've heard just on and on here, and don't want to just continue to repeat myself. But he talks about, the document preparation And that they're non-lawyers with UPL. And most people wouldn't know what UPL is. UPL is the unauthorized practice of law. And there's no reason for anybody to even know what that means. But somebody that makes that kind of statement is obviously barking up that type of tree. They're trying to make that kind of campaign. And it's not normal language that people would share or use, or that anyone should even know what it means. But Defendant Del Casal knows very well, and he talks about the document preparation, things that he doesn't know anything about. He'd been out of the premises for well over a year, and just wasn't party or privy to anything that was going on, or my involvement in the office, or anybody else's involvement for that matter, other than I suppose he was talking to Arturo. And whatever information he was gleaning, that was the information that he was putting down in this bar complaint. He talks about typists, and he goes over with typist over and over again. That's just, I did learn to type at a typing class when I was in high school, but people don't say typist anymore. It's kind of like a generational type word that you've heard it a lot here, but actually in practice, it's document preparation or it's drafting. That's generally the words that are used, but it is significant because it is a word that Defendant Del Casal uses a lot. And he talks about the documents are overseen, or I guess not, they're created by non-attorneys, and that isn't true. They're using my forms, they're using my templates. Their drafting is, it's all been set up by me. It's my heading, it's my paperwork, and I review it all. And my name is on all of it. And so they submit it, and I'm there as a limited service, in a limited service capacity, but my name is on all the pleadings. He's going on and talking about talks about the independent contractors, and they have to give money to me and information that he wouldn't know or wouldn't be privy to, and just kind of goes on and on about the unauthorized practice of law, which is not happening. There in the center and the body of it, he does invoke that Gerald Saflita is there. He says that the caliber of work is third rate at best. And the caliber of work had improved greatly over the time that he had been there. But that was something he said, and he additionally said that in the publication later on, which you're going to have an opportunity to review. He goes on to state that, he wanted an investigation, I know, of me and Mr. Saflita. Which never, that did not materialize for him. And he essentially says we're assisting.
I'm not sure the question is being asked and what is being
It's a
answered.
narrative answer. Counsel,
Seems
ask
to
your
be
question, please, and direct the answer.
Mr. Harris, he seems to take issue with, or what other areas of the running of equal rights does he take issue with in this complaint?
He accuses us of fee splitting, which is not true. Nobody splits any fees, attorney's fees with anybody. That doesn't happen. My fees are my fees. They charge money for their service, and they are, for the work that they do, they contribute essentially to the office to cover the overhead and to cover the costs.
Does he also accuse you or the other employees over at Equal Rights misleading clients?
Yeah, I think he seems to indicate that he was upset, and you've heard that that the front door says law office on the door, and it is a law office. Essentially says that the clients don't see attorneys, and they do. And he also states that there's no license, or that the private contractors aren't licensed.
Beyond the scope of the question.
He did say there are avenues on that. I'll allow this. Counsel, go ahead.
And you heard quite a bit about that yesterday. He doesn't cite any rule anywhere in any of this complaint, as though they need to be licensed or that they have to carry some kind of, he states some new rules by the state bar, but with them being part and parcel of my law firm, those rules and regulations, that he's citing don't apply to them. The good thing is it's great for them. The bad thing is I'm responsible for anything they do. Sometimes it keeps me up at night. But
Sheriff, that is the end of your answer, because you're
Thank
not
you.
going on beyond it. Next question, Councilman.
Mr. Harris, at the end there, he notes what efforts he took to resolve the matter with you.
yeah, at the end there, it just says that my efforts have been ignored. Because they want to know, the bar wants to know if you're a client, customer, if you have a reason to make a complaint, and then what efforts have you made to try and resolve the case. As I told you yesterday, I made all kinds of efforts to try and placate this individual over the course of a couple of years. And I did not know what else I could possibly do to make him happy. And I didn't even know why he was mad. But I made significant efforts. He indicates there that his efforts have been ignored.
And again, did he reach out to you in any way about any complaints?
No,
Other than email?
Other than the email that I showed you, there was an email that I'd received previously about, I just didn't think it was a big deal, but that he wasn't receiving mail that was coming to the office, and we hadn't received an email. So he was very mad about that, but I didn't have anything to forward to him, or I certainly would have.
What was the ultimate outcome of the complaint?
Bar actually dismissed it the day I responded. I responded on the last day, and I had a lot going on. And you have to respond with a mountain of evidence back because you just don't want it to go to the next level. As the attorneys can attest, when it goes to the next level, it can be very significant. And they can hold hearings and things like that. You just don't want it to get there. So you just throw everything you can in the initial phase to make sure that these types of complaints just die right there on the vine, as every complaint ever against me ever has. And so I got called from the bar that morning, and they said, "Where's your response?" And they were a little angry with me. I got it over immediately. They dismissed
Beyond
it
the
that day.
scope.
I'll allow it. Talk about the scope of the basis of our complaint. Next question, Councilman.
Was that the only, other than having to respond to the complaint, Mr. Harris, was there any other ramifications that come out of someone filing a bar complaint?
Yeah, it's a crazy thing. On your malpractice insurance, you have to disclose these. And if you don't make a disclosure on your malpractice insurance, they can deny it later. And more to my love, the insurance companies. So you have to tell them, I had a bar complaint, even if it's frivolous, and even if it's nonsensical, you have to disclose it. Now, Defendant Del Casal, he knows this. And then that goes directly to your premium. And for 3 years, you have to disclose these bar complaints every single year when you make an application on your malpractice insurance. And it costs you money. It hits you in the pocketbook. And it hurts those people that are around you just the same. Because it takes a dent in the firm, and it's unnecessary expense. But you do have to disclose them. And it's unfortunate because some people know that. And it's expensive. You end up having to pay for it.
Now, you noted in the bar complaint he uses the word typist a lot. Have you seen him use that terminology in other areas?
Yeah, he used that very frequently. And around the firm, when he would, there in Exhibit 4, when in the firm, he used to write out receipts, or he had his wife write out receipts, and it was always about typing fees or typists and things like that. And those receipts are long and lengthy. What receipts weren't destroyed that I have, and I do have an old receipt book there on the council table, that he said typists over and over and over again, that they received funds and fees for typing. And I've never ever charged a fee for typing. My secretaries, my assistants, we do not charge for them. That's included within our hourly fee. That's different than a paralegal or the preparation of documents, but somebody that just types letters for me, and that type of thing. Used to do dictation back in the past. I don't do that anymore. I type all my own letters now, but that would be a typing fee, and that would certainly be something that I would never charge for, nor would any of the other attorney that I'm aware of. You can't charge for secretarial fees.
Your Honor, I move to admit Exhibit 4. And
Hold on, sir. Exhibit 4.
these are the receipts that Mr. Harris just attested to.
Counsel for the defense, any objection?
I think the objection we had is it got into personal client information. I thought that was somewhat confidential with client talking about their domestic matters and their personal information.
Well, the problem here is the copies I have are so illegible, I can't even tell you what they say.
I have the original copy, or not copy, but the actual.
The yellow, you bring me. Counsel, no, they're not coming in. Got personal names of clients. You're not gonna be voiding people's attorney-client privilege by putting those in.
I think they were created before Mr. Harrison was involved, and therefore Mr. Del Casal wasn't an attorney, there was no attorney-client privilege.
The problem is counselor, is they're clients of that agency, and the problem is if you want to redact the personal names, I don't have a problem with it, but the fact that we have personal names in there, those individuals are not going to be part of this case.
The only other objection I noted was his relevance. I mean, when I looked over the matter, I didn't think it was.
You just established relevance. You basically said that the term typist is the term of art that's being used by your clients throughout these things. I'll allow that, counsel, and I'll allow it into it, but it'll be redacted properly. The names will be redacted.
Understood.
Therefore, 4 is admitted with the redaction stated. Go ahead, counsel.
Now, in the course of this, well, actually, sorry, Mr. Harris, I forgot to ask you. So, did you ever find out if Mr. Del Casal was upset in regard to the response or lack of response from the bar?
Yeah, when I deposed him, he did sound off about his displeasure with our state bar and their incompetence.
Now, did Mr. Franklin ever produce any documents or anything during the course of this litigation?
Not a single document, didn't produce one thing.
Did he name any father witnesses?
Never brought forth one witness at all, never filed any paperwork, never exchanged any discovery, not one thing.
If you recall, you testified about a post he made where he discussed all these people coming up to him with complaints about equal rights. Did he ever disclose any of those people?
Never got a disclosure of any of those names or any of those persons. When I asked him about individuals, I tried to pin him down at the deposition, which is a sworn question.
Mr. Harris, answer the question.
No,
You asked him about that at his deposition?
I certainly did.
That was sworn testimony under oath.
It was.
And what did he tell you when you asked him about that?
He just said he knew a lot. He had many. There were just tons of them. And when I asked for names, I never got a name. And then if I ever did get a name, somebody like Aaron or something like that he'd throw out, I'd say, well, what's the last name? And I got, well, I'm from the street. I don't ask last names. We don't know last names. We don't deal with last names. I kept getting that over and over again. But never, not one person identified that I could even verify that they were a client or try and give them a call and say, is there something I did to you? Is there something that I've done wrong? Is there something I can do to change?
Question.
I'm sorry, Arnold.
I asked that, I allowed it. Overruled.
Now, Mr. Harris, did Mr. Franklin ever make any posts indicating he had knowledge, any online posts indicating he had knowledge about the bar complaint?
Yeah, and we did talk a little bit about one yesterday, and then there was this interesting one that he made online on YouTube. And I'd stumbled across it because I was just searching during the course of the litigation. And as you see, there's a camera here in the courtroom that I believe the defendants have arranged for. It's not a normal thing for the court
Harris,
procedures.
answer the question.
But, thank you, Your Honor. But I went online and I saw on this YouTube that he was having an engagement with some individuals that were commenting and they were going back and forth. And they had accused him of essentially what I had stated in court was that, you hijacked the guy's website, you stole his website, and you redirected all that information off of his web. And he said, well, you can't do that because of this, that, and the other, he commented. But then he said, it was a bold move, bragging about it. It was a very bold move, and he was very proud of his bold move.
Mr. Harris, is that post contained in Exhibit 62?
It certainly is.
And was this something that was posted in connection to a video that you put on YouTube?
No, it was actually a video that was put on YouTube by the individuals that are here filming.
And he started commenting. Was the video in relation to this case?
It was of one of the hearings in this case that we'd had.
And he starts posting on it, commenting?
Yes.
And you pulled a copy of that?
I certainly did. There's a true and correct copy of that dialogue that went on, and there's additional exhibits that are more of that dialogue that are contained in the exhibit book. This is just that portion of it where he was making that exclamation and that admission.
Your Honor, I move to admit 62.
And Your Honor, that
Move to admit Exhibit 62. Counsel, Mr. Franklin, any objections?
No objection.
Exhibit 62 is hereby admitted by stipulation.
And this is that post.
Yeah, as you can see there on that exhibit that I provided to both the defense counsel on June 8th, about 6 weeks ago that I provided to them, you can see there that he makes that in the highlighted, though it was a bold move, as I explained in the video, I was the original creator of the Google listing and no one removed me as the original creator. He makes that admission that he'd gone in there and it represented that he was me or my business. He saw 702 Dads was there, and I don't know all the ins and outs and the technology of the internet very well. And it would take somebody that knew what they were doing, I guess, to figure it out. And I am certainly not smart enough to know what to do.
Beyond the scope.
But
Sustained.
So, Mr. Harris, he says that he was the, still listed as the owner of the Google listing?
yeah, he indicated he was the owner. I didn't know that. I just assumed when we got the bill, when we bought it with our contract there at Exhibit 1, that I was the owner. And then I had it, but apparently he had not turned that over. And so he explained he's the owner. I believe him. I take him at his word there.
You never engaged with him to do any work, online work for the business?
No, yesterday Cam said that he made an offer, but we really didn't. Cam and his little brother had made this new website, 702 Dads, and that was going to be our website that we wanted to use, and as we tried to distance ourselves from some of the angst and animus of the past.
And this Google listing was the Equal Rights for Divorced Fathers listing?
Yeah, when you type the Equal Rights for Divorced Fathers into Google, that came up, that initial landing page with the website box that we showed you in the past.
So would that indicate that Mr. Del Casal had previously engaged him to help out with creating that Google listing?
Absolutely, I'm certain that he was retained by Mr. Del Casal to create that listing at some point, or that maybe he did it on his own for Mr. Del Casal. I don't think he was paid, as we heard yesterday. He just got George to work for him for free, essentially, for whatever he did.
Okay. And then in this post, did he talk about the bar complaint?
Yeah, that was the part that you asked me that question about it that brought it up, was that he says there that I talked about the bar complaint, and I did at prior hearings. I've talked about it a lot. He says there that, you know, that information, exactly, is similar to the bar complaint, exactly, which was filed against him. And then he says there, I would bet that is where my client got that information from. I would bet that's where he got it from. You know, I agree with him. I think I'd take that bet. His client is defendant Del Casal, and that's where he got that information from.
Speculation during a business.
Sustained.
But that's his statement.
That's his statement, yeah, and I'm not involved in any of this dialogue, but apparently he would bet that's where his client got the information from. Apparently he never asked his phantom client, but that's his bet.
And he goes on to state that he posted all this on his personal website as well?
Yeah, he tries to redirect now because that website has now been shut down, essentially by stipulation or by agreement between defendant Del Casal and myself, although they did violate that stipulation. He doesn't got anywhere else to put it, so he's trying to redirect people over. Go look at my other website now. Go look where my other postings are.
There's mischaracterizing the evidence. What you just said there was not true.
Counsel, he's asking about that last line where he basically says,
That the stipulation had nothing to do with the website.
I understand, counsel, but the statement was basically that he was then referring these individuals to his own website, and basically that second to last line says, I am not afraid to be a whistleblower, which is why I posted the information on michaelfranklinjr.com, which is my personal website.
The prior statement by Mr. Harris that Mr. Del Casal was part of the website, or it's the stipulation for
Stipulation to not utilizing the website.
status quo. I think the status quo is referring to that. What he said it was not. My objection was it's mischaracterized the evidence and the facts of the case.
So the statement in regards to what the stipulation is in regards to that, this is his
Correct.
personal statement?
Right.
Okay, overruled. Next.
And Mr. Harris, does he also go on to indicate that he'd be posting or creating other content about these posts in this case?
Yeah, these individuals he's engaging in this public discussion with, he was letting them know he was gonna give them updates and be letting them know further. Some of those updates you saw yesterday.
Yeah, including a podcast.
Yeah, I don't know about the podcast, but yeah, he was gonna go big with it against me.
Now, after the bar complaint was dealt with, were there any other events with Mr. Del Casal?
Well, there were still continued postings and a few things like that, which you've heard about, which had been going on since he left the premises. And, you know, my son complained to me frequently about it, and I just told him, just please ignore it, son, just let it go. And so we didn't have any big events until the big publication on or about September 13th, 2018, that I can recall, other than just numerous posts that were ongoing.
Were there any negative reviews that were being submitted through Google?
Yeah, and as Cam testified yesterday, negative reviews were ongoing. Cam was picking them up, and he was getting them removed pretty quickly because he was able to show that most of them were fake.
And then you testified yesterday about a presentation you were doing when you got a call from your son about the website. Can you just, I guess, explain what exactly they did to the website?
Well, so as you've heard, there's the Google landing page. So if you just Google, just particular in somebody's name, I hate to use that as a verb, but Google loves it, Meta or whatever they call themselves now anyway, but if you Google the words equal rights for divorced fathers, then it pops up with this list of websites that you saw yesterday or the day before on my iPad. And there on the right usually has the business address and information there. And previously it had our business address and our information, and there's that little box that says website. You know, for more information, you click on that box, and I can't tell you how many times I've done that when searching for information about a business. But of all things, when you're going and looking for my business, it redirects you to this horrible website saying all these bad things about me and mine. And so someone had to go in there and represent themselves to be the owner of that business, not just the page or have access, but you have to represent you're the owner of that business. And Mr. Franklin saw, my website was there. He saw 702 Dad's there.
Objection, there is no proof that Mr. Franklin saw anything. Could you rephrase, please?
Okay, hold on, Counselor, first of all, she doesn't get to dictate how you answer next, Judge. Okay? It's an objection, sustain the objection, Counselor, in regards to the foundation of it, but go ahead.
Thank you, Roman. So first, Mr. Harris, Your Honor, Exhibit 2, I believe, has previously been admitted. I just don't want to put it on the screen.
Okay. 2 is previously admitted.
So when you went to the website, Equal Rights for Divorced Fathers, I'll try to zoom out a little bit so that. And this is a printout of kind of that page, right? So
Yeah. And I guess, you know, if you go to 17, even Kerry, which has been admitted.
you're talking about Exhibit 7?
Yes, sir.
Exhibit 17, it's just a printout of the Google landing page.
Yeah, and that's what you would go when you went to Google. When you Googled the name of the company, and this is where it went, and that's what it looked like. And there down at the bottom right icon, that was something new, and that was this red, white, and blue icon with a strike through the name of the business. And there in the upper left is the little website box. The way that I knew Mr. Franklin did that is because I deposed him. Counsel hasn't reviewed her own client's deposition. That's how he told me he did it. So I'm not telling you firsthand how he did it. He told me how he did it, and that's what he did. He went in there and he saw my name, and he saw my firm address there for our website, and then he manipulated it and changed it to this new website that he had created. That's what he told me under oath in his deposition, which his counsel's objected to because she hasn't read his deposition.
Counsel, answer just the question, please.
Thank you, Your Honor.
So, Ms. Harris, this is the Google page. If you were searching for equal rights, on the right side is the Google listing. And this is the box you were talking about, correct?
Yeah, and on the left side are the various websites you can go to. And I don't know if I can even see our 702 DATS. Oh, there it is, listed at the very bottom. That, the 702dads.com, that's our real site down there. But this one took you to a different, that website box took you to a whole different site that he had created.
So essentially, you just redirected it so that traffic would go.
Yeah, and the phone stopped ringing, things got quiet, and Cam was suspicious that there was something wrong. Nobody was coming in the door and the phone wasn't ringing like it normally did. And so he got online and just started looking. And when he saw that red, white, and blue icon there, he knew we were in trouble. And then my phone started to blow up, and emails and texts, and I was getting ready to take the stage. Not that anybody wanted to hear me, but, and I was just getting, my son he got a little excited.
And so when you clicked on that, this is where it took you.
Yeah.
This is the first thing you see, or you saw when you landed.
This is it. This is where it took you to learn the truth about me and mine.
When you read it, did you have an idea who had done that?
I knew immediately.
And who did you think it was?
Defendant Ernest Del Casal had written this.
And how could you tell?
Just from the beginning, I knew that he didn't have the technological acumen to publish it. And I don't either, there's nothing wrong with that. But the language, it's the same language I've heard him use for 15, 20 years. And the information that was on there, it was information only he knew, or collectively only he could know. Somebody might have a little bit here, a little piece there, as I talked about yesterday, a little brick here, a little brick there. But he had all the bricks. He knew everything about everybody, all in one place, and it could have only been him.
And Mr. Harris, if you can just kind of point us through some of the language that you saw that really stuck out as being Mr. Del Casal's language.
Yeah, I certainly will. It talks about it being an advocacy, father's rights advocacy group there, first line. I guess that was what Defendant Del Casal referred to it as that. To me, it was, it was now a law firm, and it had been a club, essentially, is what he kind of called it before, this organization. And so they were able to, not necessarily keep up with normal customs that you might abide by, but that was the first thing. And on the next page, it goes into, it talks a little bit about, the organization of October 8, 1982. I don't know who would know that other than Ernest. I don't think you can find anybody that would know that besides Ernest. I had no idea that's when it began. I had an indication that it had been at the location for about 20 years or 21 years when I bought the business, and that made it very appealing to me to have a location that had been established for 20 years. It's always a good thing with a recurring business, and so, but I didn't know it had been around since '82, and that it talks about, some of their trips to the legislature and things like that that only Defendant Del Casal would know. Then on the next page, again, the 33 years, 85,000 fathers, I have no idea. I couldn't say where those numbers came from, other than I had read them on a previous post that he had made announcing his new operation that he'd opened back in October of 2016. That was the only time I'd ever heard it, ever seen it. That was the first time I ever saw this. And so it directed me directly to him. And then it talks about the weekly education and those support meetings, those numbers down at the bottom there, which is essentially, doesn't really mean anything. It's just a historical account that he would know. And I don't know, and if you look at it from a perspective of who else would know. I mean, and I try to approach these things sometimes like, who else would know that? No one else would know that except for he and perhaps Yeah, I don't know. I don't know who else would know that besides him, to be quite honest. I couldn't even speculate that anyone else would know. He, there at number 5, though, he says that he created what's commonly known as unbundled representation. And defendant Del Casal used to tell me that all the time, that he was the creator and the originator and the author of this unbundled law. And he's very proud of that, and he made that statement. He also says that in the very next line, that until 2015, we were involved, or I was involved, or he was involved. Only a person would know when the sale actually took place, which I don't think was super common knowledge, but it wasn't a secret. But somebody would have to have all the information and would have to know that that's when the sale took place in 2015, even though the contract was signed in 2014. Defendant Del Casal knows when he left the premises, and he knows when it ended. I don't think anybody else would collectively have that information. He talks there, and we talked, heard a lot of testimony about this, that things came to an abrupt halt when the director and founder, he calls himself the founder and director there at the bottom line. Again, that's how he referred to himself. That was not a term that I heard anybody else use, other than by him. I never had used that term, and don't know anybody anywhere that ever did. In the time that I knew him, almost 20 years, at least 15, I never heard anybody say that but him. This is just, I don't know how Michael Franklin knew that was me. I didn't know the guy. I'd never met him. I don't think he ever saw me that I'm aware of. I never saw him before I filed the lawsuit, but he knew it was me when he published it. And it was a good guess. I mean, I don't know if there's a lot of other Kurt Harris's out there, I don't know, but he knew that was me. And he went online, and in his deposition he told me that he pulled that off and that he had created this. And I just thought it was odd that he could know that it was me, with that degree of certainty without verifying that with someone else who would have known that that was me. And that was just something that just stuck out to me at the time.
Yes, they state in here too that you approached him to take over the business. Was that something that was common knowledge?
I don't think that was very common knowledge at all, actually. I know that he was shopping it around to others, and I talked to other individuals who were considering purchasing it. Ed Miley was the name that was brought up yesterday, and Roger Giuliani and some others were thinking about buying it, or at least had entertained some ideas. When I heard that he was shopping it to be sold, I let him know that I was interested. If that's approaching somebody, then I guess that would be true. But I don't know how anybody else on earth would know that from a private conversation that took place between he and I. It talks there about the good work of BDR there at the top after the director retired. And then it just immediately kind of turns on me there that sadly I made representations that never happened or ended up being complete falsehoods. Or who else would know what representations I ever made? There's only one person in this room, or I don't know, that would have any motive to write this, that would know whatever representations I made. And as I said yesterday, I may not have made the representation that women are going to be involved. They're going to be allowed to come in. We're not going to do that anymore. And I don't know if he thinks that was a misrepresentation maybe that I made in not carrying on the good work, but I didn't really say anything about it, but I never had any intention of ever barring anyone from coming into my office. And so I don't know if that's what he's referring to in this drafting, but only he would know what representations I made. That could only be defendant Del Casal.
Does any of the language kind of mirror the bar complaint?
Well, it sure does, because the bar complaint talked a little bit about tried to take it off and was bartering on the good name, or the longtime support group had retired, and there was this changing of the guard, as it were. All that mirrored exactly what we saw in that bar complaint. And then it just says that shortly after the director retired, down there below, things went downhill, and I actually thought things had gotten a lot better, and that was the reports that I was getting. And if there was a negative report, we addressed it as quickly as we could. That's just good business, I guess. I know Cam talked about that a little bit. We try to be customer service oriented, and I think things actually got way better. We talked a little bit about some of the costs and the expenses that went into office improvements, and the big thing really was e-filing, because we didn't have people running around back and forth anymore. Just said, give me that paper, I scan it in, and it's filed, and you can go home. And here's a copy. Rather than having them run around and file things at the courthouse, come back, go mail something, come back. We just eliminated all that and streamlined and put systems in place, and it just created a lot more time for the paralegals to work, a lot less distraction, and that was something that I thought was an improvement. I didn't think that was downhill. Still had some great attorneys that I could refer potential clients over to, and I brought in Mr. Doyle as a referral source as well, knowing that I could trust him and that he would take care of people. And that was a change that I'll admit to, but I thought that was an improvement as well. As far as statewide advocation, I don't know if that ever took place. I don't know anything about that. I wasn't party to that. I don't even know what the expectation of me is to advocate statewide. I don't even know where to begin with that exactly, so I can't really respond to that. But it states there that fathers found, and these unnamed fathers found that fees, services doubled and tripled overnight. And that just isn't the case. We eliminated the membership fee, and then we brought in additional benefits. So in a vacuum, you could say, well, you're charging twice as much, and that would be accurate, I guess. But the level of service was 3 and 4 times what people were getting, and what they were paying and what they do pay. It's a bargain. It's a deal. I don't think anybody can beat me, but maybe they can. I don't know. I don't know who is or isn't. But we give a great service for people, and we charge a very fair fee for what they get. But I don't think that you could say that the fees doubled and tripled overnight and be fair about that. And the attorneys, as far as my recollection and my knowledge, every attorney, they're absolutely allowed to charge whatever they want. I don't think that's ever changed one bit with anybody. You heard from Mr. Miller yesterday that he didn't change anything. I haven't changed anything. So that just is inaccurate. The next page in his deposition, Mr. Franklin couldn't really explain to me why he put the beware there, enter at your own risk up there, but it does have a certain connotation, like you're taking a risk if you go there. You're taking a risk if you do business with those people. And I don't think it's fair. But it goes on in the first line there, the once not-for-profit. It was a for-profit enterprise when I bought it. To say that it was not-for-profit, that's not true. But I know that Defendant Del Casal frequently characterized himself as a not-for-profit. Nonprofits filed several of them. They're a pain in the neck. You got to go through 501(c)(3), you got an application to the IRS. It's a lot of work. It's a lot of paperwork. It's filings every single year, declarations. If you represent yourself as a nonprofit, you better be a nonprofit. It's, they're not pleasant things necessarily to set up or to manage. This was never a nonprofit. This was a business. It was being run, and it was a business for profit.
Mr. Harris, does he use that typing phrase in this?
Yeah, then it's just become an expensive typing service designed to lure fathers. I wasn't really, I didn't think I was luring anybody to anything. I just took over. I never, I'd only heard typists from defendant Del Casal.
Yeah, he actually uses it twice in there, right?
Yeah, it comes up twice in that sentence that, you know, it really kind of hammered home, like, this is defendant Del Casal, this is Mr. Del Casal, this is who the author is, typist, over and over again. I'd seen it in the bar several times, the bar complaint as well, and seen it on, you know, throughout the office previously, and so it really was a word that I would.
I don't see the word typist on this page.
Page, we now, last time we had the page with the shark was on it,
Right.
Page 007.
007.
It actually states typing service, which is, I think, what you originally said.
Counsel, jury understands what the statement was and what was said by the witness. Continue, counsel.
Mr. Harris, does he start talking about your son,
Yeah.
Cam, here?
Objection, Ms. Kerry Doyle, he's referring to Mr. Del Casal as the one who drafted this, so I think it's an objection as to mischaracterizing evidence or argumentative.
Okay. Rephrase your question, counsel. You did refer to him being he, and that would make a statement.
Understood. Does the Post then comment on Cam?
Yeah, this website made a comment on Cam, and you know, you know, cameras here and all, and I hate to air anybody's laundry that's not my own, but that's just not common knowledge, and it's just nothing that anybody should care about or anybody should want to care about. But that was information that defendant Del Casal knew very well, and it was, yeah, it's not something that, it's true, okay? So it doesn't break my heart. It gets Cam a little fired up, as you saw here in the chair. He gets a little angry about it, just because that's not something that's commonly shared with the world. It's not something that we really tell anybody. And I don't know why anybody would even care. But defendant Del Casal would know that that's the kind of thing that would really dig at Cam, that would really hurt him, that would really make him mad. And you heard that he'd gone somehow and gotten the court records, and I thought they were sealed as far as name changes go, but he found out what Cam's original birth name was, and then he created a Facebook account or started making comments
Objection, Your Honor.
with that name.
He's still accusing Mr. Del Casal of doing these, so it's assuming facts, not evidence.
Sustained.
Well, it is my firm belief that he's the only one that could have known that information and had any motive or the time on his hands to go figure those things out, because nobody else would care. And as you go on there, it's interesting that it's stepson in 2 words, and I really don't know how to spell it, but it's capitalized. Like, I want to emphasize this. I really want to pound this home. I want to drive this home. I want to make sure you see this. I want to make sure you know it. It's obvious that the writer of this really thought he was making a statement or really was going to, you know, really make people angry or mad or out some secret information.
Speculation, objection.
Sustained.
Would Mr. Franklin, who admitted to posting this stuff on behalf of someone else, would he know that Cam was your stepson?
Not a million years.
Does the posting go on then and start talking about you personally again?
Yeah, it comes back around to me. You know, they do comment first that my son is only there to make money, and I do find that to be odd. I guess even nonprofits make money. It's you know, people make salaries when they work in nonprofits. I don't know where this
Beyond the scope.
Overruled.
mindset is that you're not allowed to be paid for your work, or that you shouldn't be compensated for the work you do. But it just says there that, you know, he's only there to make money off fathers. And, you know, I just, it makes that statement, it comes back into me personally, but I just, you want your money handlers to be trustworthy. You want the people that you hire at your business to know that they're gonna keep your money safe and take care of those funds, and somebody that you don't have to worry about, you know, embezzling your funds or something. And I can't think of a better person than my son to handle money. So it just, yeah, he would collect funds. He would give people receipts. He would process credit cards. That's what office managers do. He acts as the cashier. And so, of course, he would receive funds. And then it goes on to me that, the manager steps on of me. He receives a very large portion of typing fees. I know it doesn't say typist, but it says typing. And that's just not true. Cam makes a salary. He does some work on the side for Nevada corporate headquarters. Yes, I helped him get that little contract job as well. And he does work for other aspects of my firm, for which he gets paid for as well. But there's not him keeping some portion of fees.
Does it go on to accuse a business of hiding money?
Yeah, I think that there's this, well, the way I understand it, the way I take it, obviously, it says we now prefer to be paid in cash. They only received cash before I got there. They didn't take anything but cash. And I witnessed, I can't say how many times, Defendant Del Casal telling people, go over to 7-Eleven, hit that ATM, and come back with cash before I'll talk to you, or before you're gonna get anything here. You need to get a membership, and he'd tell them, go over to 7-Eleven, go to the 7-Eleven. It's the opposite. It is, we would prefer every other method of payment because we can track it and get a better record of it that way. If someone happens to have cash, absolutely, we take it. I don't know anybody that doesn't. Well, I do now. Yeah, I went to Las Vegas Ballpark the other night. They don't take cash. But sure, we take all forms of payment. But to say that we prefer and somehow insist on it, that was him. He was the only one that did that, and that certainly was not my preference. It says there that there are rumors, and I don't even know how you can respond to rumors. You can make stuff up all the time online and say that, well, I've heard rumors, and there's really no way to disprove something that isn't true. But that they charge fees for that are not authorized by the state, and I don't know what that means, and not on the payroll, but Cam is on my payroll. And it means that and it just makes this leap to there must be undeclared cash and income.
Does that sort of, to you, indicate, sort of in line with the bar complaint that there's unauthorized practice of law? Is it saying that,
It's right in line with what we read in the bar complaint. It's right on point with somehow trying to make this insinuation that there's some kind of nefarious activity going on over there and hiding money or laundering money. I don't know how you take that exactly, but nobody wants an IRS audit, but I guess if he really was convicted to it, I guess he could make a complaint to them. He may have already, I don't know, but we file our taxes. Cam gets a W-2, he testified yesterday, and I pay taxes. So I'm not sure what he's up to.
Does the posting go on then to start taking personal attacks at individuals over there?
Yeah, and then it goes on the personal side of things, and you heard about that yesterday, and I don't want to belabor it. Honestly, as far as the comment about George, did not know that. I think George suspected that Cam told me because he confided in Cam. Cam didn't tell me that. I found out about George and Scott by reading this. When I get asked, or make statements about is it hurtful, it hurts a lot worse when it's about your friends and your family. I don't really care. As far as me personally, I'll be okay. I don't like my business getting harmed. I don't like their livelihoods getting damaged and their ability to make a living. I don't like the fact that, my son has got, personally my 4 grandkids to feed, and that George has got a couple of kids to feed, and that their livelihoods get threatened. I don't like that at all. Yes, that hurts me, and yes, that makes me angry. I did not know these things about Scott and George, other than I tell Scott all the time he needs to stop smoking. And I'm concerned about him. But you saw them, you're able to evaluate them and look at their credibility. But the only person that would know about George's past, defendant Del Casal. I didn't know. And I don't know who else would know on earth, because that's information 34 years old that I don't know why anyone would share that with anyone, except in extreme confidence. And then with Scott, Scott just seems like a nice guy to me. But the broken down thing, they're good people. I don't find them to be broken down at all. I know they kind of laughed and scoffed at it, but that was kind of, they really take, what I've observed from them and seen them work with people, they really are, they get with people, they sit with people, they talk to people. When they do discovery for people, they sit down, they ask questions, they get information, they fill it in. And they're very caring, very kind people. They're good guys. They get along really well, and their rapport with the clients is amazing. Arturo's wasn't so much. And that was part of the reason why I think Arturo left, because he just didn't want to learn, he didn't want to work at it, he didn't want to go to school and really make big improvements. And then on some of the comments that I had made, he just didn't want to make changes.
I think we're getting onto a narrative objection.
Correct, sustained.
Mr. Harris, was there anything else in this posting that you wanted to point out as being something that indicated that Mr. Del Casal was the author?
Yeah, I mean, it says there that we're just taking money from desperate fathers there at that top paragraph, and that, that fathers believe they're retaining a real advocacy group. And I don't know why anybody would be under that assumption, or why anybody would think that they're walking into some kind of advocacy group when they're going to get legal help. And it's not a nonprofit, it's not a public institution. They're going to a private office with a private firm. But defendant Del Casal always characterized himself as being an advocacy group, that he advocated on behalf of the cause, I guess, and I appreciate championing the cause. I just advocated on behalf of everyone, and most importantly, I try to advocate on behalf of kids, even sometimes against my clients' demands. It says that fathers have reported, and yet I've never heard one report, and haven't had one father disclosed who's made any reports about not seeing me or some other attorney with their legal questions. That's just not true. And then it just goes on to say that I'm assisting them essentially in the practice of unauthorized practice of law, UPL, same thing we saw in the bar complaint. Defendant Del Casal's fingerprints are all over that. And then it says essentially it makes a representation there that when they do make a request for an attorney, they see only me. I try to see as many people as I possibly can, but there are other attorneys that they do see, and that is just not true. And it isn't some system that they are somehow tricked into coming to see me when they're given several cards and given several choices about who they want to see. And they're able to get a free consultation from any of us, and they can compare us and contrast us, and they can make a choice about who they want to go with.
Is there any other language or commentary?
I think that, well, there's more graphics there on the next page about buyer beware, and obviously we all know what that means, and it seems like a warning not to go there. It talks about me having a fancy office on Fort Apache. I'm listed in the bar at that address, so that's public information. I don't know. I guess it's fancy. It's not overdone by any means, and it's an office where I share space with a very large client. Down here, though, this is where it really strikes, and I know that there's been a lot of questions about we make money off every turn at the end of that full paragraph there. We just really don't. We actually give people quite a bit of value for their dollar, and we don't really make a lot of money. If they need service of process, we send them over to June's Legal Service. We don't get any kickback from June's. We don't get anything back from them. I know when Ernest referred people over for service, he would get a little kickback from the person that he referred to. His name was Troy Gonzalez. We tell Junes, thank you, please take care of our people. Please go out there and get these things served, and please charge them a fair price. $39.50 for service. That's June's price, not our price. We send them over there. They're an independent business. They do their own thing. We don't make money off them at every turn. We just don't do that at all. If they need somebody third party, we send them over there. There's no remuneration that comes back my way, just goodwill in the community, because those things do come around. And then, you know, I know that it's been asked, I don't know how many times about they can't figure out what's defamatory here, and I think most of this is defamatory. But it says there that many have found that Kurt Harris and his stepson Cam Harris to be less than trustworthy, honest, or sincere in their dealings with them, the attitude they project. I think that's really just critical there, because under the defamation per se cause of action that we're here for, if you make a comment about somebody in their business and say that they're less than trustworthy, or make some comment that might lower their status or their position in the community with the service that they provide, that's defamation per se. You're attacking their business. That's not saying it's the worst pizza in town. I know because I've tried it. That's saying the owner of that pizza parlor is corrupt. He'll steal your money, and he'll charge you for services that he doesn't give you. The trustworthiness and the honesty and sincerity not so much, but those other two, that cuts straight to the heart of a cause of action for business disparagement and defamation per se about me personally and about my business. And it meets all the elements as it was published to the world online. And there was no qualifier here as to how anybody had a license or any right to make these statements. And one of the ways that you get a right to make a statement is that, hey, I tried it, tried the pizza. I tried that attorney. I was a client, I was a customer. Not these straight up accusations about trustworthiness and honestiness. I know that we attorneys don't have the best reputation on earth. We just don't. But some of us are honest. Some of us are trustworthy, and some of us do what we say. And I like to think I'm one of them. And the people that I surround myself with are as well. And we take that real serious. Then it goes on to say that there can be no doubt, and it's not an opinion. When you say there's no doubt, there's no doubt. That's what you're saying. You're not leaving an opinion. You're not making some offhanded statement. You're telling people there's no doubt that me and my son want to gladly separate desperate fathers from their money, and that we're fakes and phonies in the opinions of some. Again, if they would just bring somebody forward who really had some knowledge of that, who was credible, who was independent, you know, I would really take that to heart. And I want to know what happened, what went wrong, where did I go wrong with. But there aren't any, and they haven't listed any, and they don't have any. You're not going to hear from any. And so I know that Ernest drafted this. It goes on there to say enter your own risk. It's a tough thing to say that, but yeah, okay. I think you do that with any business, I guess, to be fair. But there are a lot of people that I get a lot of good referrals from that come out of the court system, mediation, a few things like that. They find me to be trustworthy. Legal aid refers me. It's crazy. If you go to legal aid and you own a house, you can't get legal aid. And so sometimes the ladies there will refer this over to me to represent at a very reduced rate because they own a home, their husband's left them or something like that, and they have a house and they can't qualify for legal aid. Then they'll refer them over to me. I would hate for those people to see that because they know that I'll take care of those people, and they know that you know, I don't make a judgment on them on whether or not how much money's in their wallet or their pocket. I appreciate the referrals from them, and I work hard for them, men and women alike. And so I think down there at the bottom, though, I think in just summation, and I'm sorry I've just gone on way too long, you know, just don't be a sucker and check around. You know, I think it's an obvious statement that if you go there, you're a sucker. And you know, it talks about other outlets, other avenues, one of which, he doesn't name himself by name, but Defendant Del Casal puts himself out there as one of those other alternatives. Thank you.
And Mr. Harris, there on that page, he calls them expensive type, oh, I'm sorry, let me rephrase. The posting states it's an expensive typing service again.
One more time, yes, it's kind of indicating there that all that anybody does there is types. And that just would not be the case.
While we're looking at this post, the big red X that was placed across, or not X, but the no sign, I guess, that was placed across your face, is that something that you had seen in other places?
Well, yeah, it is actually. First time I ever really saw it on myself, well, publicly anyway, I'm sure it's been done. But yeah, I've seen that before. And so I had an idea of where I had seen that before, and I think it's Exhibit 20 is where I had seen that, and I think there is I got a like color picture of it there behind you there somewhere.
That Exhibit 20 references, did that kind of come up earlier in testimony?
Yeah, it came up earlier in my testimony yesterday, and one of the posts that Mr. Franklin had made, he talked about this banner that he was preparing for Judge Marquis. Linda Marquis, he said that the banner was getting done after they showed a picture of that trailer with some of that printing on it, and that I've got this banner, Judge Marquis, coming up.
Who made that statement?
Oh, that was Mr. Franklin had mentioned that. He mentioned it on Mr. Del Casal, or it was Defendant Del Casal. I can't remember which had made it. I think it was Mr. Franklin had made it on Defendant Del Casal's website or vice versa. I can't remember who made that statement exactly, but I did get a picture of the banner.
And that was in connection with the new business that he had started, the Facebook posting?
Yeah, I think it was mad. They were mad at her about some client of Mr. Franklin was angry with Judge Marquis.
And they posted a picture of that?
Your Honor, I'm just going to object. I think there's some foundation in this series. The witness here has indicated confusion as to, if we can turn that exhibit, I think some
Well, I haven't
foundation.
even had a motion to move the exhibit into evidence right now. We're just talking about apparently this no sign or this line through the face sign. Counsel, we moved to try to amend or admit 20?
I was heading that way, Your Honor.
We lay the proper foundation to do so, Counsel.
Right, I think we were referring to an exhibit that's already been admitted, I believe it was discussed.
The previous exhibit in regards to sort of being admitted was the actual Facebook page in regards to that. But now we're talking about the actual exhibit 20, which has not been admitted to evidence. The foundation has not been laid for it. Counsel, next question.
Yes, Your Honor. Mr. Harris, do you recall which exhibit the Facebook posting was that you're referring to?
Sorry, I'm looking for that right now. You had the picture of the trailer on it. Yeah, I do actually. I just now sort of recall because I found it in 52. To help counsel refresh his recollection of yesterday's testimony. There on 52, which has been admitted, at the bottom, there's a statement on Mr. Del Casal's Family Court News, and the statement is made on his news, and there's that trailer there with Mr. Del Casal's phone number on it, the Father's Helpline. And if you look at the font of the trailer, and then it says, you know, this is my new trailer, wait until the end of the week, new banner is on order for show, that's not my word, for show Judge Linda Marquis what she is doing against fathers and veterans.
Okay. And then on the same Facebook page, was that a picture of that banner later posted?
Yeah, then there was that banner. Well, it came up later on that I saw it.
And you pulled a picture of that off the webpage?
Yep, it's a true and correct copy of it. I found on their webpage there, or on Mr. Franklin's webpage, which is Exhibit 20.
Your Honor, I'll move to admit.
Counsel for the defendant, looking at exhibit 20, any opposition to that?
I did a living it's inapplicable, we also need some foundation. We don't believe any of these events. We think that plaintiff's confused on this exhibit.
So what's the objection, counsel? The plaintiff is
Foundation, because we had nothing to do with defendants, this exhibit, we object that it's inapplicable to this case.
Okay, let me actually.
And therefore lay some foundation.
Okay. Mr. Harris, the document that's produced as Exhibit 20, Did you produce this document?
Yes, Your Honor.
And where did you get the picture of this banner from?
I pulled that offline of defendant Franklin's webpage.
Okay, so the picture we have before us is only of the actual sign. Where is the portion that shows that it was originated on a Facebook page?
I did not include that as part of the exhibit, Your Honor.
Okay. So council lay foundation in regards to that portion in order to get this thing admitted.
So when it's posted on the Facebook page, it has a photograph, is that what you're saying?
Yeah, it had that photograph. I was kind of interested in following up on the comment there about Judge Marquis, because I'm kind of friendly with her and I think she's a fantastic judge. And so she does guardianship, which is tough. And so I followed up on it and I looked and I went to Mr. Franklin's, one of his websites, and I found the actual banner that he referred to that would be coming out. And I knew that Mr. Franklin had helped out Mr. Del Casal with banners in the past, and he testified at his deposition that he'd done that.
Foundation, as to what Mr. Franklin did with Mr. Del
He was just
Casal.
saying he's testified.
Testifying to it, that is the foundation. Let's find out how he knows that, counsel. Was he aware of it? Was it in the office? Did he see things? Lay the foundation for that.
Well, how did you find out that, when you took his deposition, did he tell you that he had produced things like this in the past?
I'll allow it. It's foundational, counsel. You can even ask for foundation.
You know, as I stated, I took that prior sworn deposition of him and I asked him about the fees that he had paid while he was at Equal Rights. And he indicated that most of the work he had done was trade work. And we have the deposition to review. That he'd done trade work with Ernest for those, preparing banners and signs and doing work on the web as trade.
Sorry. On the Facebook page, it was him that posted it,
Yeah, it was him that he posted it.
and then well, you can interact with the photos on Facebook, right? You can click on them and.
Yeah, and he had a client who was this, I guess he calls himself Veterans and Fathers Rights Organization. And they're one of Mr. Franklin's, according to Mr. Franklin's webpage, they're one of his clients that he does web work for them. So he had posted this banner quite proudly.
And this photo, is this photo the picture that after you click on it on the Facebook page, it's been enlarged?
Yeah, it's a smaller photo that scroll down, and then when you click on it, you can enlarge it, and there it is. And that's been produced to council years ago.
You're not object to this, I'm not sure why it's relevant to this case.
I know, well, the relevance is that they're believing that this typical circle with the line through it was utilized in other portions of the website pages and was utilized in one that was produced by your client. Relevance is overruled. Counselor, you stipulate to the admission of it, or are you still objecting to the admission of this document?
I just have foundation for the, your Honor, because there's been enough laid, but.
I believe it is, that's why I'm asking Ms. Anderson if there's any additional objection.
Your Honor, again, my objection stands, that has nothing to do with Mr. Franklin did not prepare that either.
Okay, it was on his website though, that's where he said he received it from. He can dispute that, but this individual said he received it going from a website that was prepared by your client. You'll have the ability to dispute that. 20 is hereby admitted. Council, we're going to take our afternoon recess. Time for lunch. Ladies and gentlemen, we are going to take our noon recess now. You're not to talk to or converse among yourselves with anyone else on any subject connected to this trial, or read, watch, or listen to a report of or commentary on the trial or any person connected to the trial by any information, including without limitation, newspaper, television, radio, or the internet, or former express any opinion on any subject connected to this trial if the case is finally submitted to you. You're not to do any experiments or investigation regarding matters raised in this trial, nor are you to post any social media forms about the trial or attempt to investigate anything you heard in this trial using any form of social media or the internet. Based on that clock, we'll see you guys back here at 1:15, please. Thank you.